Hello and welcome to this premium podcast on the origins of intersectionality, which is a bane on human existence, but you're going to tell me all about it.
Yeah, well, the very term intersectional as a political dog whistle comes from Kimberle Crenshaw's 1989 essay, Demarginalizing the Intersection of Race and Sex, a Black Feminist Critique of Antidiscrimination Doctrine, Feminist Theory, and Anti-Racist Politics. What a title. But as you can see from just the very nature of what we're dealing with here, like this, anything that flows from intersectionality is, of course, deeply grounded in leftist thought. So conservatives saying, why can't I be an LGBT conservative? Because you can't be wet and dry at the same time. You know, you're not communist, and that's what they're doing here. Unless you are, of course, a feminist, or, an anti-racist Marxist, then you aren't that thing. Right. So anyway, beginning with this. Crenshaw's fundamental contention, which she repeats in a later and more famous essay called Mapping the Margins, which is part of the Critical Race Theory Bible that I've almost finished, is that there is a unique vector of oppression for black women. And this is because they face a combination of oppressions because of their identities of both being black and being women. So it is, of course, presupposed that black women are just oppressed always, in all times and all places. And this is because in terms of race, black men are prioritized, and in terms of gender, white women are prioritized, and therefore black women are being left out of the analysis. And maybe in 1989, this may have had some validity to it, to be honest. It's hard to know. But she says, I will center black women in this analysis in order to contrast the multidimensionality of black women's experience with the single-axis analysis that distorts these experiences. Not only will this juxtaposition reveal how black women are theoretically erased, it will also illustrate how this framework imports its own theoretical limitations that undermine efforts to broaden feminist and anti-racist analyses. So what you can see, this is actually a kind of assault from within leftism, because the anti-racist and feminist politics are not as all-encompassing as they could be. And so this is kind of inevitable, really, that this would come about. And it's, I guess, just a matter of time until someone like Crenshaw pops up and says, well, hang on a second. Why can't we just combine these axes of oppression into multiple identities? It's like, well, there's not really any reason, to be honest.
You've got activists fighting on what they would call, you've got the women's rights groups, the racial rights groups, gay rights, so on and so forth.
Yeah.
Throw them all together. Why not?
Yeah, and the critique is that the questions that are being raised by left-wing ideology here are just not being implemented consistently. You know, there are groups that are being left out, the margins, as it were, which she is trying to demarginalize, which means promoting the supremacy of. And so she says that this requires the construction of a new multi-dimensional framework of thought, which is what she calls intersectionality. She says, these problems of exclusion cannot be solved simply by including black women within an already established analytical structure. Because the intersectional experience is greater than the sum of racism and sexism, any analysis that does not take intersectionality into account cannot sufficiently address the particular manner in which black women are subordinated. There's something special and different about black women.
But also she's arguing that you must take all of the different identities that you could possibly have as vectors of oppression.
Well, that's right.
Listening to this, I would have thought this would be a joke, like something Tatiana McGrath would write in the 80s, and be like, yeah, but what about heightism? Am I right, bros? Because that's where this is going to lead.
Well, that's exactly where this goes. Yeah. And that's why you've got the Twitter bios of LGBT intersectional activists that just look like a caricature at this point.
But this, it sounds, at least if you knew nothing about modern leftists, if you were living in the 80s, this sounds like a caricature I would have imagined of what the left is.
Well, you'll notice this is part of her long march, because she's still very much politically active now. In fact, she must be unbelievably thrilled with the success of intersectionality, because back then, and spoiler alert, to just spoil the conclusion of the essay quickly, she recognizes this is going to take many decades of work to get this recognized, and she did get it recognized. So anyway, she begins by examining the existing anti-discrimination framework in the US legal system from a legal perspective. And so she considers three cases in which she feels that black women have been unfairly treated. The first is DeGraff and Reed versus General Motors. So in this case, 5 black women brought a suit against General Motors alleging that the employer's seniority system perpetuated the effects of past discrimination against black women. Evidence produced showed that General Motors simply did not hire black women prior to 1964, and that all black women hired after 1970 had lost their jobs in a seniority-based layoff during a subsequent recession. The district court granted summary judgment for the defendant, rejecting the plaintiffs, so the black women's attempt to bring the suit, not on behalf of blacks or women, but specifically on behalf of black women. And so the court said, well, you can't do it on behalf of black women, but you could do it as blacks or as women. The court decision was that they failed to cite any decisions which stated that black women are a special class to be protected from discrimination. The court's own researchers failed to disclose such a decision. The plaintiffs are clearly entitled to a remedy if they have been discriminated against. However, they should not be allowed to combine statutory remedies to create a new super remedy, which would give them relief beyond what the drafters of the relevant statutes intended. Thus, this lawsuit must be examined to see if it states a cause of action for race discrimination, sex discrimination, alternatively either but not a combination of both. And that's interesting, isn't it? Because this means that the court has explicitly rejected the premise of intersectionality, that you can combine these oppressions to create these sort of super identities.
They haven't rejected them. They've said it's not law.
Sure. Okay. That's, yeah, fine. But the legal standing at the time is from within the legal system and the legal framework. That's not an acceptable thing. And the thing is, again, this opens a door to Crenshaw, because why can't she make that argument? You know, if you can be a black and you can be a woman, why can't you be a black woman and receive double protections? And so she says that, you know, that black women are protected only to the extent that their experiences coincide with either of these two groups. Where their experiences are distinct, black women can expect little protection. And so, if anything, it seems that intersectionality is this inevitable outgrowth of the civil rights ideology of the United States in the late 20th century. So the second one is Moore versus Hughes Helicopter Inc. So Moore, being the plaintiff, was alleging that Hughes Helicopter practiced race and sex discrimination in promotions to upper-level craft positions and supervisory jobs. And they basically come to the interpretation, she comes to the interpretation, that anti-discrimination doctrine is insufficient to the needs of black women. So what happened in this one, quote, Moore introduced statistical evidence establishing a significant disparity between men and women and somewhat less of a disparity between black men and white men in supervisory jobs. And the court responded with, Moore has never claimed before the EEOC that she was discriminated against as a female, but only as a black female, so being a black female specifically. This raises serious doubts as to Moore's ability to adequately represent white female employees. Again, like, they are uncomfortable with them combining these identities. And so Crenshaw says the curious logic in Moore reveals not only the narrow scope of anti-discrimination doctrine and its failure to embrace intersectionality, which is something she's just made up, so why would they embrace it? But also the centrality of white female experiences in the conceptualization of gender discrimination. So if she can't represent white women, she doesn't get to argue that it is on the axis of woman that she's being discriminated against, because it's just an abstract categorical. In fact, she says, this relegates black women to being some kind of sub-woman, in her view then. She says, one inference that could be drawn from the court statement is that Moore's complaint did not entail a claim of discrimination against females, is that discrimination against black females is something less than discrimination against females. Possibly. That's one interpretation. And so the court rejects this bid to represent all females because of her attempt to specify race. Crenshaw suggests this reveals the limits of the scope of anti-discrimination law, which it does, I suppose. Moore illustrates one of the limitations of anti-discrimination law's remedial scope and normative vision. The refusal to allow a multiply disadvantaged class to represent others who might be singularly disadvantaged defeats efforts to restructure the distribution of opportunity and limits remedial relief to minor adjustments within an established hierarchy. Obviously. You know, the anti-discrimination law in the United States wasn't meant to be revolutionary to destroy the established institutions of the country. It was designed to prevent oppression and undue discrimination against people who had been historically disadvantaged. And really for anyone, it should be. But it's only going to be minorities who are going to be claiming this.
I find it interesting that both of the cases you cited there, that she's citing, neither of them does she actually demonstrate there was direct discrimination against black women as a subgroup. She just says, in the first case you had there were layoffs based on seniority, not on race or gender. in which case, well, there was no discrimination on race
Yeah.
or gender. You're just arguing from equality of outcome.
Yeah.
Yet again.
Yeah. And the court sided with the defendants in these. So
Yeah. But also the point there
Yeah.
being that the current legislation, as you could argue from the civil rights, you can say there's an ideological, will to go towards intersectionality, but they already worked. Like, they already had the laws against discrimination on race or sex.
yeah,
And these ladies
we're
were
going outside of those.
unable to prove it even on those bounds, never mind when they then said, well, actually, on the specifics of being a black woman I was discriminated, they couldn't prove that either.
No. The third one is Payne versus Travenol. In Payne, 2 black women brought a race discrimination suit against Travenol, but the court would not allow them to represent black men, only black women. Quote, ultimately, the district court found that there had been extensive racial discrimination at the plant and awarded back pay and constructive seniority to the class of black female employees, but despite its finding of general race discrimination, the court refused to to extend that remedy to black men for fear of their conflicting interests that would not be adequately addressed. So this it was a strange ruling from the court here, to be honest, but there is at least a victory here for the intersectional side.
Well, that would be because they were able to prove that black women specifically were being discriminated against, presumably.
Yes.
That is the case.
Yes. But that was strange that black women can't represent blacks because some are men. She says, like in Moore's attempt to represent all women employees, failed as a consequence of the court's narrow view of class interest. And so what she thinks is that this shows that US anti-discrimination law is insufficient. She says, in several courts have proved unable to deal with intersectionality, although for contrasting reasons. As a consequence, the employment experiences of white women obscured the distinct discrimination that black women experienced. And what's interesting now is that she then addresses the apparent inconsistencies in her charges against the anti-discrimination doctrine. And the contradiction is actually quite subtle, and it is to Crenshaw's credit that she spotted it. She says, I seem to be saying in one case that black women's claims were rejected and their experiences obscured because the court refused to acknowledge that the employment experience of black women can be distinct from that of white women. While in other cases, the interests of black women were harmed because black women's claims were viewed as so distinct from the claims of either white women or black men that the court denied to black females representation of the larger class. It seems I have to say that black women are the same and being harmed by being treated differently, or they are different and being harmed by being treated the same, but I cannot say both. Quite clever. But she then just sort of skips past this because, of course, she just says that this is just further evidence of the limitations of traditional anti-discrimination law and black women's omnidirectional oppression. So she says, I'm suggesting that black women can experience discrimination in ways that are both similar to and different from those experienced by white women and black men. Black women sometimes experience discrimination in ways similar to white women's experiences, and sometimes they share very similar experiences with black men, yet they often experience double discrimination, the combined effects of practices which discriminate on the basis of race and on the basis of sex. And sometimes they experience discrimination as black women, not the sum of race and sex discrimination, but as black women. And it's not inconceivable that black women are in some way uniquely disadvantaged by being both black and female. So the charges kind of do stick within the framework of anti-discrimination policy.
Does she not grant this to anyone else?
She's only examining black women during this. So I mean,
she couldn't fathom a possibility that a white man could be discriminated for being white and a man.
Well, I get you're very much jumping ahead here.
To watch the full video, please become a premium member at lotuseaters.com.